let us look at what are the key issues that may arise when you want to terminate somebody who's working with you. Okay, I'll show up the exercise in a bit. One is that the person is not being productive, and that is on the basis of performance. And the second could be on the basis of disciplinary grounds, right? Now, any challenges on the grounds or any other inputs on the kinds of grounds that you see termination being carried out, Abhilash and Krish?
Other than the disciplinary and
Performance-related
performance?
grounds, disciplinary grounds. Disciplinary grounds is typically misconduct, which is elaborate examples of misconduct is given in the Standing Orders Act, right?
Yeah. Termination, end of contract.
Expiry of contract, okay. So expiry of contract is a very interesting one. For most employees, you would have them on a fixed employment basis, and anytime you had to let employees go, it would qualify as retrenchment earlier. But now they have introduced something called a fixed term employment. And other than contract labor, the expiry part did not happen. And even in the case of expiry of the contract, when the contract labor was engaged with the contractor had to take care of all the necessary compliance. So the laborer or the workman, his engagement terminates with respect to the principal employer, but with respect to the contractor, the laborer might be still engaged with it. But after introduction of the fixed term employment system in early this year, after that, what has happened is that you can have a written contract which says when the terms of the person, when the employment of the person will expire. Okay, and in that way, I think that is one small step in making labor legislation in India more friendly to organizations. Otherwise, India is supposed to have very strict labor law rules, especially for large companies. Because if you have more than 50 people or more than 100 people, depending on whether the Standing Orders Act is applicable, the criterion might be 50 people or 100. In some cases, it may be even lower, but I have not done a full-blown research into all the states. But when the Standing Orders Act is applicable, or when the Industrial Disputes Act is applicable, then all of these situations where you actually ask workmen to leave, it amounts to retrenchment, and then retrenchment compensation is payable, and they have to be given a notice of termination of 1 month, or in case of places which have more than 100 people, 3 months notice has to be given. What are your observations or challenges or experiences in connection with this, Abhilash and Krish? I'm looking forward to interactions with you because my intention is to make this relevant, okay? And we have a very varied audience in this course. So I want to be able to address the needs of different segments of people. And it may be that you face a certain kind of challenges, but others don't, and others face other kind of challenges. So I want to be focusing on the things that you don't already know or you don't already deal with. And, these classes also enable us to actually identify what is it that people in the course want so that we can make the course great, right?
Yeah. So, Abhir, on my personal experience as a HR and compliance personnel would be like, we have our stores getting contract laborers who are in huge numbers, and yeah, what you said is right. Fixed term contract has come in, has given us a great relief, because earlier, if an employee is told to leave where the contract is closed and the contractor doesn't follow the proper procedure of termination or end of contract, that always used to come back to us as a principal employer. And there are cases where we have been a party or to the case where the contract employee has filed a labor case, and we were the parties. So
the
that
contract
tends.
employee has been illegally terminated by the contractor, and then he goes not only against the contractor but also includes you in the legal proceeding, and then you have to take the hassle of defending yourself, and all the legal costs you also have to bear. Is that correct?
Absolutely, yes. That has been a case, and so the entire proof, like solving that key. Okay, standing our thing. It was in our part that we did not terminate him. We have asked for a replacement. We have see his attendance. He has not come in. and that's a long process, and we also have a expenditure and things which are coming up on that front against us. And one more thing would be the name reputation of the company also goes on toss, because most of these contractors, once our name or principal employee name is there, they generally don't represent, and there is a fair chance of getting ex parte also. So
Right.
all this, all these concerns were there, and currently I think with fixed term contract that is solved. And being a vibrant in e-commerce industry, what we have seen is like due to the growth, there is always a new store or a new location which we open up, and places where we close also. So both that transition has to be properly handled, and smooth transition is always a critical part of our job.
Got it. So are you now, so usually the principal contractor, sorry, usually contractors have a bigger network of labor under them. So are contractors or are companies like yours directly entering into fixed term contracts with employees now?
No.
No.
Still we give that contract to the third party vendors, and they are in turn using this norms to get that thing done.
So the contractors are themselves entering into fixed term contracts with contract laborers.
Absolutely.
Okay. Okay. How is it benefiting them? Because they have to extend the benefits that are applicable under other laws to contract laborers. But a lot of benefits kick in after, let's say, 1 year or 5 years of the employee working. For
Correct. So
example,
there are two
yeah,
ways of it. Housekeeping and security agencies don't idly go with the fixed term contract. These are the players like who get sudden contracts from companies where they have specific numbers and they are only catering to one specific principal employer. Whereas in case of housekeeping, security or maintenance kind of thing, they don't bother about that. They take them still on their roles, and they need not bother a fixed term contract, because if it closes, if they're the contract closes with A company, they push them to a B company because they are in the huge network. Like G4 security guards, they have in pan India everywhere. Even in Bangalore, if you have one company, A company closes the contract, they have B company where they always have a shortage. So
right.
they never get into contract. They just move them from this principal employer. Okay, done. I'll give you next principal employer. Please go
Yeah.
and work there.
So for them, what is the insight? What is the benefit of fixed term employment?
For them, they don't use that at all.
Right.
For them, it would be for them it's not, but for the contractors, smaller players, they can use this because
Right.
it would be for 9 months or 1 year contract, and if they
Yeah.
take them on rules, that will not. And especially what I have seen is now this is helping the IT and ITES companies,
Right.
contracting staff companies of IT
Correct.
and ITES, because their projects stay for 6 months, 1 year, 1.5 years,
Correct.
2 years max. So they are using it to full-fledged extent rather than other manpower contractors.
So if you are in an industry where you need to increase manpower based on a project, and the project lasts a certain period of time, let's say 5 months, 10 months, or 1 year, then you can actually give a fixed term employment contract. The law has,
Absolutely.
the notification has prohibitions on converting existing employees into fixed term employees. And the law also says that any benefits that you would extend to an ordinary employee will be extendable to fixed term employment contracts. I was reading some articles on the internet which were on issues such as whether gratuity and all of that is payable, because the law says that certain benefits are payable. So my view is that all of that will not be payable. Provident funds maybe, because that applies to an organization that exceeds a certain size. So when you exceed that, then provident fund you will have to extend to fixed term employees also. However, things like gratuity will not be applicable unless the fixed term employee has actually worked for 5 years. Because if an ordinary employee gets the benefit of gratuity after working for 5 years, then you cannot give a higher benefit to a fixed term employee than you would give an ordinary employee. The intention of bringing this notification on fixed term employment was so that your fixed term employees, or so that people can be employed on a contractual basis without imposing too much onus on even the employers or organizations. So you cannot put that disproportionate responsibility on them, because in that case then fixed term employment will become preferable for an employee in comparison to regular employment. So one has to be careful about how we interpret that notification.